Welcome everyone to the IAPP web conference, Grappling with the FTC's Safeguards Rule, New Requirements and How to Comply by Ketch, sponsored by Ketch. My name is Jordan Hardy, Programming and Speaker Specialist here at the IAPP, and I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form on our website. I also want to let you know that a recording of this program will be available in your My IAPP, My Purchases, My Recordings portal within 48 hours. So if you just sign in on the top right of the IAPP website, you'll get to the recordings portal. Now onto our program. I'd like to introduce today's panelists. There are some polls in the program that we'd love for you to engage in, and please feel free to post any questions that you have for the panelists throughout the program in the Q&A area at the bottom. And with that, I'll hand it over to our panelist, Jonathan, for introductions.
Hey, Jordan, thanks. So humbled by the turnout here. We appreciate it, and thanks for the opportunity to talk about this. As Robert and Laura know, I'm not a lawyer, but I frequently am happy to give legal advice. But I won't be doing that today, given that we've got our esteemed colleagues, Laura and Robert, here on the call. Laura, do you mind introducing yourself, and then we'll go to Robert.
Yeah, thrilled to join you today, JJ. I'm Laura Van Druff. I am a partner at Kelley Drye in the Privacy and Information Security practice, where I provide client counseling on privacy and security issues and in contested matters with the FTC, state AGs, and the CFPB, among other agencies. I was a manager in the Federal Trade Commission's Bureau of Consumer Protection, in their Division of Privacy and Identity Protection shop, which is the shop responsible for the safeguards rulemaking that we're going to talk about today, as well as data security and privacy. In between my time at the FTC and Kelley Drye, I spent a couple of years at AT&T as their consumer protection subject matter expert.
Thanks so much, Laura. We are really excited to have someone of your expertise here with us today. We would get nowhere if we relied on Jonathan to lead us through such things. So my name is Robert Cunningham. I'm the head of legal at Ketch, and I'm just a humble CIPPE under the IAPP, and everything I know about the FTC, I've learned from Laura and the great folks at Kelley Drye. So we're happy to have you here with us. And as Jordan mentioned, we're going to kick things off right now with our first poll. And the question is, how prepared are you for the amended Safeguards Rule? You might say, I'm ready, I'm just here for the CPE, good on you. Or we're working on it, or haven't started, or finally, what's the Safeguards Rule? Let's see what folks think about that. Good to see that there's some willing to admit the CPE is the main draw. All right. Oh, still going. Okay. Maybe we'll consider that done. So what do we got here, folks? We've got a lot of people working on it, so that's great, and a good reason to be here with us. Even better reason to be here with us is haven't started, and perhaps the best reason might be what's the Safeguards Rule. And that final one is relevant for our next slide, actually, because we'll talk about how you might become a lot more familiar with the Safeguards Rule. So why is this topic important? By the way, folks, I think you have to click off the poll if you want it to disappear for you, but why is this topic important? Well, the scope of the rule is broader than it was previously. That's important for your participation and your learning. The requirements of the rule. There are new obligations that were not in the old rule from 2003. There is a new element of technology that will be part of complying with the amended Safeguards Rule, and that is a novel consideration. For example, what's a system inventory as required by the amended rule? We're going to talk about that so that you are prepared for that requirement. And there's also potential for future and broader impact, because this Safeguards Rule, as it has in the past, is likely to affect other sector-specific regulations and state laws, like California privacy law, for example. So these are 4 great reasons for you to have joined us beyond just the CPE, and we'll touch on all of these as we go through the details of the rule. And with that, I will turn it over to Laura and her expertise to educate us on the final rule. So Laura, please take it away.
Yeah, so I'm going to actually back up, not even the final rule, but just where are we? What is GLBA Safeguards? Answering that 4th question for folks who answered the poll question with, hey, what's safeguards? For nearly 20 years, the Safeguards Rules required financial institutions to develop, implement, and maintain comprehensive information security programs to protect their customers' personal information. Such programs must be appropriate to each entity's size and complexity, the nature and scope of their activities, and the sensitivity of the customer's information at issue. Now, for a generation, the rules requirements have influenced data security standards in other sectors, emphasizing a flexible, process-based approach. If you've watched the FTC's security program, you've seen the influence of the Safeguards Rule. The amended rule, which we're going to spend our time talking about today, replaces just some of that flexibility with more specificity, and Robert highlighted some of that at the top. Violations of the Safeguards Rule are enforced through the FTC Act, but unlike other FTC rule violations, Safeguards violations are not subject to civil penalties. We saw some of the names of not individuals, but entities that had registered for today's webinar. And some of you may be wondering, why am I here? Because I don't know what I don't work at a bank. What is a financial institution? And that definition is broad. It includes businesses that are significantly engaged in financial activities. And the definition was expanded in the amended rule to include significantly engaged in activities incidental to financial activities. And we'll get into that in a moment. Judging by the interest in the rule and in this webinar, the bar understands the reach of the rule. Just a little bit of DC history before we move on. This rule amendment has been in the works for a long time. The agency sought comment on the rule as part of its periodic rule review in November 2016. The FTC engages in periodic review as just a matter of good government, has done that for a long time. In 2016, it sought comments on some issues, including, for example, the need for an incident response plan, integrating some definitions, but there wasn't a suggestion at the time that a rewrite was in the works. In April of 2019, so 2.5 years later, the agency issued a notice of proposed rulemaking with most of the material changes that you see in the final rule. In July of 2020, then, a year or more than a year on from that NPRM, the FTC held a workshop concerning the proposed changes. And then in October of 2021, just a few months ago, announced the final rule, which was then published in the Federal Register earlier this month. We have an effective date for nearly all of the changes in the rule and all of the changes we're going to discuss of December 9th, 2022, a total timeline of 6 years. So then we get to who's affected, the slide that we've got up now. It includes businesses significantly engaged, as I mentioned, and that is a diverse set of businesses. Some of them are identified in the statement of basis and purpose. Mortgage lenders, payday lenders, finance companies, mortgage brokers, account servicers, check cashers, wire transfers, travel agencies operated in connection with financial services, collection agencies, credit counselors. It goes on and on. But again, it comes back to this significantly engaged definition. And then finders, which is the addition to the rule. The amendment expands the definition of financial institutions to expressly include finders. They are defined as companies that bring together buyers and sellers of a product or service for personal, family, or household purposes in a manner that's incidental to financial activities. And these include lead generators that help consumers find a financial institution for like a home mortgage or car insurance. If we could advance to the next slide. Terrific. So, so what's in the changes for the Safeguards Rule? We're going to spend most of our time talking about certain of the specific requirements required to be included in a company's safeguards. This is number 1 on the slide. The amended rule included other key changes that we wanted to identify before we moved on. So in the second box there, the appointment of a single qualified individual. It's akin to a requirement that a company have a CISO, which was the FTC's original proposal. But in issuing the final rule, the FTC recognized that not all financial institutions, smaller businesses, didn't necessarily need to compete for the same talent as larger, more complex businesses. In its SBP, the commission said it, quote, did not intend to require that all financial institutions hire a highly qualified professional with an extremely high salary, regardless of the financial institution's size or complexity. But the final rule does require that a financial institution have a person who is qualified responsible for the Safeguards program. That person must be qualified to oversee and enforce the financial institution's information security program, and the qualifications that are necessary will depend upon the size and complexity of the financial institution's information security and the volume and sensitivity of the customer information that the financial institution possesses or processes. The third big change that we have up on the slide relates to finders, which we described. And then lastly, small businesses. The rule limits the extent to which smaller financial institutions are covered by the amended Safeguards Rule. Financial institutions with customer information of fewer than 5,000 customers are accepted from certain requirements. If a financial institution maintains fewer than 5,000 records of fewer than 5,000 customers, the commission reasons that that information is proxy for the level of security necessary in light of both the risk of attack and potential consumer harm if there were to be a security incident. But they're still, and they're accepted, I should say, from a written risk assessment, continuous monitoring or annual pen testing, a written incident response plan, and a written report by a qualified individual or that CISO-like role. But they do still need to comply with other aspects of the safeguards, the amended Safeguards Rule. Finally, yes.
Oh, I'm sorry. We had a question from Amy, and I was wondering if we could answer it. We could answer it now if appropriate, or answer it later about the retention requirement. She asked, she said, can you tell us more about the 2-year retention requirement relating to customer information? Should it be interpreted as a maximum 2-year retention period, and which circumstances would that apply?
Let's circle back on that after we just run through this, JJ, but I do appreciate Amy's question, and we'll come back on that. Do appreciate that, Amy, though. Thanks. And forgive me, Amy, I'm going to circle back on that very quickly. I mean, in a moment, I don't mean very quickly. Go ahead, Robert.
Laura, to tie off on that fourth point about small companies. So is it fair to say that smaller or companies with fewer customers unfortunately still have to familiarize themselves with the rule because some things are still relevant while other provisions are not. Is that fair to say?
Oh, absolutely. That's right. Yes. Yes,
Okay.
that's exactly correct. And I appreciate that clarification.
Well, no, I believe you said that, but it's true for a lot of the other laws that we talked about as well. And I wanted to make sure that folks understood that unfortunately you still might have to give it a read, even if you have a limited number of customers.
Well, and that give it a read is a really great point, Robert, because that was my last point. We don't have this up on the screen, but one of the biggest changes in the rule, if you did what I did, which is run a red line of the new rule against the old rule, it's just a sea of red. And the reason for that is that the FTC took many of the cross-references to statutes and regulations of other agencies and put them into the rule itself so that practitioners didn't have to spend a lot of time at the risk of paper cuts to try to understand exactly what definitions applied, and instead imported those into the rule itself. And while it is really a change for the practitioners here, it is I think an improvement in the rule, even though it is largely a technical change. Okay, so with that, let's see if I think we're on to, yes. So why did the changes matter? Bear with me. The safeguards rule is limited to financial institutions, which, as we've discussed, is very broad. The granularity of the controls announced, which we're going to get into in a moment, are likely to influence financial institutions' contractual terms, which I suspect Amy's question gets at. This is of concern to the entire industry. On a practical level, too, the new safeguards rule may serve as a model for data security standards in other sectors. It was true 20 years ago when safeguards was the first regulatory data security standard. And we expect that it's going to continue to be true today. If we have time, and I expect that we will, we're going to talk about this in a bit. The FTC has also proposed to require notice to the FTC when a financial institution determines that there's been misuse of consumer information and 1,000 or more consumers were affected. This proposal may set the stage for additional burdens on financial institutions and other firms. And we've seen that the FTC and the CFPB and other regulatory agencies are starting to flex their muscle in these and other spaces. The rule change could affect the scope of state privacy laws, as Robert described at the top, some of which exempt data covered by GLBA from their requirements. This is true to different extents in the CCPA, Colorado, and Virginia state laws. And then while safeguards doesn't include civil penalties, businesses should take note of the various efforts underway by the agency to create a basis to assert civil penalties under a variety of scenarios. In its statement of regulatory priorities just last week, the FTC took credit for this rulemaking, which in light of the timeline is interesting. I mean, certainly it came out this year. But there's a big focus on regulation from this FTC and this administration. So it's something that all of us in this space are taking a close look at.
For my money, Laura, the most interesting bullet on that slide was the first one, which, correct me if I'm wrong, demonstrates this move from a flexible principles-based approach to, as you stated, a more prescriptive approach by the FTC. And I know that that's something that is happening or being considered in many other regulatory spheres as well. To, for example, go from a type of law that might require appropriate technical and organizational measures for security to actually institute more specificity around what that means. So I want to point that out for folks as another reason to sink your teeth into what we're talking about here, but it is no longer an idea that is, hey, make sure you think about this and put something in place that you would find reasonable. It is a shift toward, we have told you some things now that we have decided are reasonable and that you need to do.
That's exactly right, yes. And the timeline in which the FTC came to the conclusion that these are the reasonable solutions suggests that there isn't going to be a nimble shift in landing on those answers. Okay, I think we can move on to the next slide. Robert, shall I start here, or would you like to?
Well, I can kick us off. What we're going to do now, as advertised, is move into a discussion of not all of the specific requirements that the amended rule describes, but some of them. And we've chosen these at our discretion for various reasons. We're going to start with a discussion of access controls, and then we're going to speak to data and systems inventory, and we may touch on multi-factor authentication as well. Again, to repeat, there are more bullets here than we have bolded, and all of it is relevant, but we've picked out the high order bits as we see them, and as we may be interested in describing them undeniably. So let's start with access controls, which I believe will move us to the next slide to go into a little bit more detail.
Right, so on access controls, the FTC concluded that it applies to all customer information, whether it's housed in information systems or physical locations. Here, really applying the principle of least privilege, not appropriate to give all employees and service providers access to all customer information. As privacy professionals, this is understood by everyone on this call, but security professionals, this isn't something routinely necessarily incorporated in their review, but now is required for financial institutions. As noted on the slide, the risks associated with inappropriate access controls have been seen over and over again in significant data breaches. And as a consequence, the FTC is requiring in its safeguards rule, and its amended safeguards rule, that financial institutions implement access controls and restrict access only to customer information that's needed to perform a specific function. And again, this really implements the privilege of, the principle of least privilege, and it is irrespective, again, of electronic information systems, but also applicable to physical locations. So it does harken back to the safeguards rule of 20 years ago, which while that was a data security rule, was also focused on the physical location too.
Hey, Laura.
Yeah, go ahead, JJ.
Go ahead.
Oh, sorry, just picking up one of the questions in the chat here. Are there other agencies in addition to the FTC that are responsible for rulemaking here under GLBA safeguards? Or is it primarily the FTC? The question was, what's the likelihood that these changes will influence adoption of similar regulations by other agencies? And I think we talked about the influence this may have and the importance for other sectoral laws and even state privacy laws. But it seems like this question is about other agencies that are responsible for GLBA.
I love that question. I think it's really interesting. So yes, there are other agencies that have safeguards requirements. Those requirements haven't. They haven't followed the FTC yet. Could they? I suppose the FTC covers the broadest sector of the economy because it basically applies to everything else. So not banks not federally insured credit unions, not entities regulated by the SEC, et cetera. But what I'd observe in response to the question is that if you align the New York State DFS cyber requirements and the FTC Safeguards Rule, you'll see a number of similar requirements. They don't align perfectly, but they are similar. I think that the Safeguards Rule picked up sort of the best of the New York DFS. What we talked about at the top is that this could establish where things are headed, because again, Safeguards has for 20 years established a baseline. Whether that'll be true for safeguards by other regulatory agencies or just more generally remains to be seen. And I don't practice before those agencies, so I'm the wrong lawyer to be asking to prognosticate.
Certainly, Laura, it seems that since I don't move in a FTC social network, for example, I guess I can say this, but if you look at what the FTC recently did with respect to the health notification breach rule, there's no, what's the word? There's no humility or no hesitation to assert influence in sectors and in ways that are almost explicitly seemingly forbidden by the text of the rules themselves. All of that is to say that this could be stretched more broadly because we have evidence that this FTC wants to stretch things more broadly. And so that makes it interesting and remains to be seen whether we'll be right about that. I wanted to make a final point on this slide, the access controls and the bolded language we have here. For folks who have any familiarity with access control, it's often been a relatively crude implementation of role-based access control. So if Jonathan in solutions or marketing is allowed to see certain data assets because by virtue of his role in the org chart, then he has access, and Robert for legal, et cetera. It's a lot harder to enforce what you might call purpose-based access control, where the inquirer is seeking to use the data for a particular purpose, and that should be the criterion by which access is given or not. That is a hard technical problem, but it's one of those that the law is saying that's what you need to do, so figure it out. We know that because at Ketch we're working on solutions that apply that purpose-based access control rather than role-based access control. So another technical issue here that's a lot thornier than it might appear just reading those words as they wash over you. JJ, anything to add about that?
Yeah, such a great point, Robert. It's when I think about access control, it's typically been, like you said, when we say role-based access, it's access that someone in the organization has to a system. And what's implied there is that you have access to all the data in that system. So you may not need access to all that data in the system. In most cases, you don't. The other important, I think, consideration is the folks within the organization that have access to a lot of systems and therefore a lot of data are primarily in that IT and technology department. And I think that creates a weak point, right? And kind of like it says here, access to a system by impersonating an employee. If it happens to be a technology or IT employee, through that access, you get access to a lot of systems. And access control is changing. And I think the way that it's changing is the way that you described it. Some people call it purpose-based access control. Some people call it purpose limitation. I don't think as an industry, we've decided what it is. But the point is, how do you allocate access to data at a super granular level as that data sits inside a system rather than just providing access at a higher level? And where purposes come into it is people are accessing data for a particular reason. And that reason could tie to purposes as defined in GDPR as an example, or other legislation. Your purpose could be targeted advertising. Your purpose could be analytics. So I think the next generation of access control will be, let's give people access to the data they need to perform a function or a specific task. And related to that is the security piece on top of that. And what I mean by that is, what format does the data need to be taken? Does the data need to be to be accessed? And what I mean by that, sorry for the mumble there, is Does it need to be tokenized? Does it need to be anonymized? So in addition to granular access to data, we can also set policy for when that data is accessed, which format does it need to take? And so you start to bring in these security elements there as well.
Or perhaps to nuance that a bit, JJ, as I often do for your statements, if you're getting access to a data set and you can use it more flexibly and more confidently, if you eliminate risk from a certain piece of the data set by pseudonymizing it or tokenizing it, it can make the data utility a lot higher. So a certain data analyst or data scientist can pull over a huge data set quite efficiently and do whatever he or she wants with it in the comfortable knowledge that rows 7, 8, 9, 10, and 11 have been obfuscated from his or her view so that they don't have to worry about that. Anyway, we may have belabored that point. Let's
actually we haven't, Robert. So Greg actually asked a great question, and it's so multidimensional. I'd love to get to it. So Greg asks, are there real world examples of how to approach purpose-based access control? And is this an issue we need artificial intelligence for? And Robert, it touches on one of your favorite topics, which is purposes versus cookies, I think. So Greg, there are real world examples of this. One of the ways we think about it is you see a lot of cookie banners out there. And you see cookie banners and it came from e-privacy and whatnot. But basically you jump onto a website and when it asks consumers for consent, it's something like, here are the cookies that are strictly necessary or functional or whatnot. And I mean, it's a whole other conversation to talk about the consumer experience there and what that actually gives you from a trust and transparency perspective. But some of the real world examples are to move away from cookie-based consent and actually be transparent about what you're collecting data for, the actual purpose. And an example might be, we're collecting data for analytics. We're collecting data to run targeted advertising. We're collecting data for personalization. So you ask for consent as needed by the jurisdiction, opt in, opt out, whatever the case may be, based on the purpose. And so if you've set up your privacy management software to be thinking about the purpose rather than the cookie, and the cookie being a subset of that, Greg, I think what you can do is you can translate that into access. And one of the reasons why we see that starting to happen is that these worlds around privacy and data governance and security are converging. So if you set up privacy right and you set it up with purposes at the heart of that and permissions for those purposes, those same purposes can inform access control. And Robert, I know this is kind of one of your little kind of favorite things to talk about. So anything to add there on that?
No, I'm shocked that you seem to have hit the nail on the head there. But what I would add is that when the data subject, we're speaking in a sort of a European sense here, but it's universal enough that I hope the folks, I hope no one's offended. When the data subject gives whatever the appropriate legal basis is, consent or does not object to an asserted legitimate interest, think about mapping that to role-based access control. They didn't say the marketing team can look at my data. They said, I permit you to use my data for targeted advertising. They didn't say the HR team can look at my data. They said, I'm okay with you analyzing my data for employee practices or candidate recruiting. That's the kind of mismatch that needs to get fixed. And to take it back to what we're talking about here today, wittingly or not, the FTC has said you need to have that kind of access limitation, as Laura has instructed us thus far. So speaking of technical challenges, let's move to another one that the Safeguards Rule has brought up, and that is new. And so we'll go to the next slide, and that is this discussion of a systems inventory, to borrow the phrase from the rule itself. We put the text of the requirement right here on the slide. You don't need me to read it to you. Essentially, the FTC is now requiring institutions to obtain a, quote, clear picture of their data and the systems in which it resides. And if you read the rule itself, they are not hiding the ball in saying that this will require relatively sophisticated technical solutions to be able to do this. So we are going to dig into this requirement. Laura, we have a poll question about this, but is there anything you'd like to add about this inventory requirement right now before we move on to the poll?
No, I like the poll. Let's do it.
Okay, to the poll we go. So speaking of systems inventories, how good is your data inventory today? Well, how about I have a perfect data map, thank you very much. Or we have a data catalog, but there are gaps. Third, it's the best spreadsheet ever. And fourth, let me get back to you on that. You may note, by the way, systems inventory, data map, data catalog. We consider these to be synonyms, and we don't mean to imply any meaningful difference among all these phrases. The industry has not coalesced on a way of speaking about these things. So results are coming in. No one has a perfect data map, JJ. Whatever shall we do?
Robert, while the questions are coming in, and in lieu of me humming the Jeopardy theme, we're getting some questions, and Amy's question's still pending. I want to we'll respond to Amy's question and the questions that are in the chat maybe at the conclusion of this, so that folks don't think that we're ignoring the questions. Okay.
We certainly are. We've never been known to dodge easy or hard questions, and we're not about to start now.
Right.
So so it looks like these are good results. I love the 30% who need to get back to us on this. The honesty is encouraging, and we're here to help. Spreadsheets, if I have a favorite topic, JJ can talk all day about spreadsheets and their potential inadequacy here. And love that some people have a data catalog, but acknowledge that there are gaps. So let's move to the next slide. X out the poll if you all need to, and we'll turn it over to JJ to take us through in more detail this new systems inventory requirement in the final Safeguards Rule.
Thanks, Robert. And I'll quickly address Sunday's question about what exactly is a data inventory. I mean, absolutely, right? There's so many words for it. We call it data discovery. Some people call it data mapping. Some people call it data inventory, as you kind of rightly pointed out, Robert. What we're trying to do is establish where the sensitive and personal data is in an organization. And I think this is what we mean by data inventory. Yes, you're looking at data more broadly than sensitive and personal information, but really you're doing this to identify where that sensitive and personal information is in your data systems. And I say data systems because I mean internal data systems, but I also mean data that might be sitting with service providers. And that's really what we mean by data inventory, Sunday. And so what's been interesting here is with this FTC rule for GLBA safeguards, it's to me a recognition by regulators that there's a technical solution here that has to be part of this. And people have started to talk about that more and more. When we first started to try to comply with these privacy regulations, it was a little ad hoc and manual, of course, right, Robert? I mean, 2016, GDPR very quickly implemented in 2018. We responded with a lot of manual effort to be compliant. And now, given the increasing scale in regulations out there, we're seeing more programmatic, more automated solutions for that, only because we have to, because we can't keep blowing budgets up. And the analysts like Gartner and Forrester have started to recognize this, that we need to move away from paper-based compliance and move into what they call data-based compliance, which is a term that Forrester uses. And Gartner talks about this as well, but they talk about data discovery as an example within the context of a data lifecycle. And kind of to your question, Amy, about retention periods. You've collected data. There's a retention period associated with that under some privacy laws. That needs to be dealt with at a pretty granular level because some data needs to be retained at different time periods and whatnot. So for us, data discovery becomes this really big piece of complying with privacy legislation, and it's had its challenges. One of the first challenges is that it's been extraordinarily manual and time intensive. Spreadsheets, as Robert rightly noted, were the key to how to do it. Interviews, manual surveys, basically asking different data owners across the company, what kind of data do you have that you use in your everyday business, and what kind of data sits in that database, and where is that database, kind of thing. So you can imagine how cumbersome it is to pull that together. Secondly, as soon as you pull together a data map or a data inventory, it's almost immediately out of date and static, given the nature of how quickly data changes within an organization and data gets created and recreated and moved around. There's no real confidence with a manual approach that you've picked up all the data that exists within an organization or picked up any changes. Thirdly, I think this is relevant for how data discovery fits into a privacy management program. Is for a long time they were very separate, and data discovery being so manual didn't help with solving in an efficient way privacy management use cases. And Robert, you've got a couple of really good examples here that I'd love to talk to you about. But we'll touch on that in the next slide. But then fourthly, it's not all manual when you do data discovery. There has been some solutions, some technical solutions that have come up, but we believe a lot of those technical solutions have increased the complexity and increased security risk. So, as an example, building a data inventory in a way that creates a parallel data lake. If you need to pull data out of a system so you could store it somewhere else, increases security risk, and there's new ways to do that, which we'll talk about. And let's kind of talk about that now on the next slide, please. So here's what's happening today. Given that some of these challenges need new ways of thinking when it comes to technology. You don't need to connect to data with surveys. You can connect to it with technology, and there's a couple of ways to skin that cat, which we can talk about. Secondly, we talked about this a little bit when you talked about access control, Robert, but this idea that you can control data at a very granular level, I think, is important. And so one of the ways we solve for data discovery, having been static and incomplete, is to connect directly to data systems and be able to control at a cellular level, essentially, who sees it and when, and that's always on. So it changes and reflects based on the latest state of the data inventory. Third, I think this is the part I think is one of the most important. This connection between data discovery and your privacy management program gives you a whole lot more effectiveness in your privacy program. And I think a couple of examples of those, Robert, are around getting more granular in data subject requests, as an example, and dynamic records of processing activity. I'd love you to talk a little more about those two.
One way of thinking about this, if you are a budget-constrained privacy professional at an organization, is to think, well, how fortuitous. The FTC has broadened the scope of institutions covered by the Safeguards Rule. Now we are covered. It turns out that they are mandating a granular systems inventory as part of the new rule. And lo and behold, over here on what used to be sort of a separate other side of my tasks, I need a record of processing activities, or I need data protection impact assessments, or I need privacy impact assessments, or I need transfer impact assessments. All of these other requirements from various other privacy laws can be much more efficiently dealt with and indeed solved by having this systems inventory as the foundation of what you're doing. So the FTC has given you a perfectly good reason to go ask for a budget, or if you have to, ask for people to be able to build out this capability so that now you can do those ROPAs, that you can do those DPIAs or privacy impact assessments, so that you can respond to data subject requests for access to data or to the deletion of data in a much more technical rather than manual fashion. So there's certainly silver lining here, and I don't mean this to be tongue in cheek. This is a mandate, and a mandate is one way to draw attention to some lingering needs from some of the laws that may have predated this new rule.
Yeah, thanks, Robert. And look, not to get too much into the technical aspect here, because I know this is primarily a legal discussion. So we'll make one more point, then we can get to some of these questions. There's a new idea when it comes to the technical solutions here, in that you don't need to pull data out of all the systems in which it resides and have it in a central place so you can do this type of analysis. So you can manage a data inventory or manage access or whatnot. And there's this idea that the exfiltration of data to fulfill some of these use cases isn't necessary. And that's essentially how we built Ketch. The idea is to build a way to control data, but have that data remain decentralized. So data stays in all the systems that it is. And from a central location, you can apply policies to that without having to pull that data out. I think that's been one of the novel advances in the space here. And it's been something that's been received very well by security folks who don't want to manage a parallel database or parallel data lake, and also this ability to remain flexible with the data underneath. And so what's the benefits of doing that? Let's move to the next slide. And there's a few good questions that we should get to. By doing this data discovery, by doing this map, as required now by this new FTC rule, understanding your data, you can immediately start to think about which data isn't necessary. And by that, I mean, you can start to reduce your data surface area. And we've seen in some cases up to 30%. We frequently talk to companies who don't know exactly the extent of their sensitive and personal data. And as they dig into that, find out that they have collected way more than they need to, or it's outside the retention period or whatnot. A lot of reasons why that's important. One is just the sheer volume of storage cost today. 700 grand per petabyte per year. If you can reduce that footprint by 30%, is a huge saving for most people. And the other angle is a reduced risk of a data breach as you minimize that data surface area. And Robert, you pointed out this ability to connect data discovery with some of these privacy management use cases makes privacy teams much more effective and much more efficient in their compliance needs and in their building of ROPAs and building of privacy impact assessments and whatnot. So a lot of reasons to do this.
Well, there's an additional reason, which is that the text of the rule requires companies to periodically assess how much data they are retaining. So this isn't just about, oh, we can save more money with our S3 bill with Amazon and with AWS. The rule tells you to stop keeping data that you don't have a reason to keep. And so this is not just an optional inquiry.
Yeah. And Robert, there's a question from an anonymous attendee that might be related to that. He or she says, we were talking about the impact of this rule on financial institutions, but what about on financial institutions service providers? So these vendors to financial institutions. And I'd love you to talk about that a little, Robert, too, because I know we've been dealing with this a lot with other privacy legislation, and that you can't deal with that contractually. There are some other ways that you should be enforcing those privacy choices.
Well, can I jump in also here?
Oh,
first?
yes, absolutely.
Yeah, so there's a legal answer that, and then I think reaching the data inventory is important, but looking at the rule and the question was about the amended rule, but we can look at both the original rule and the amended rule in 314.1b. The rule extends to all customer information in your possession, regardless of whether such information pertains to individuals with whom you have a customer relationship or pertains to the customers of other financial institutions that have provided such information to you. And thinking about that, service providers are in an interesting position. The FTC brought a case in 2019 against an entity called Dealer-Built, which was a service provider to an automobile dealership. And it was a service provider, and there was a safeguards count. And so while the FTC did not make in its business guidance about the case, didn't talk much about that aspect of the case, it did extend safeguards in that matter to a service provider. So it is something that when I'm advising clients that I keep a very close eye on in response to the question.
Thanks, Laura.
Yeah.
Before we go to the next slide, this is maybe a good time to get back to Amy. I've lost track of the list of questions.
Yeah, so Amy's question, and I really appreciate it, and I deferred on it because while we were addressing data inventory, I wanted to just go back to the commentary to make sure that there wasn't something in there that I was overlooking with respect to disposal. And for the benefit of others, because we haven't talked about disposal, the amended rule imposes requirements about disposal. There's a bullet up on the slide for folks who are looking at this after the fact. And Amy's question was, is 2 years a maximum for disposal? And the answer is yes and no. It's a maximum, of course, if the if the information, unless the information is still needed for a legitimate business purpose. The commentary really doesn't shed any more light on that, except to run through on the one hand, on the other hand, of the comments that were received in response to the NPRM. And so this is an issue on which you're going to want to do a deep dive with the business and document the business purpose if customer information is maintained for more than 2 years. But in keeping that 2-year timeline at front of mind, the clock runs from the quote use or connection with the provision of a product or service to the customer. So it is not 2 years in your database. It's 2 years from use or connection with the provision of a product or service. So it may have a longer life in your systems.
Thank you, Laura. Let's, with that, keep generating questions. We got some time left, but let's go on to the next slide, which is a little bit of a zoom out to 2 things, one of which we talked about a little bit, and one is a little bit more novel. There are going to be, this is the one we have mentioned, there are going to be ramifications and an expansive effect to this rule. It has, as Laura noted, been a model for other sectoral laws and agencies in the past, and this new prescriptiveness and some of the details of that prescriptiveness will almost certainly appear in other locations. Maybe use that as a tailwind of saying we're doing this for a good reason because it will help us in the future in other areas. As well as the second bullet there, that it does relate to some of the state privacy laws. For this audience, obviously something that's relevant. Some of the state privacy laws exempt information governed by GLBA, others exempt entities governed by GLBA. It's complicated. I'm sure you're all familiar with the gray areas, and this furthers that complication. Second piece here, Laura made brief mention of this earlier, is that at the same time that the amended Safeguards Rule has been published, a new proposed rule has been offered up, which is a new notification requirement for data breaches related that are governed by the FTC in this area. And correct me if I'm wrong, Laura, but mandatory federal notification rules are quite rare, quite thin on the ground, and this would be an additional one. And they're soliciting comments on it right now. One of those comments, solicitations, has to do with, well, what needs to be in your notification company who has suffered this breach? Is it just a description of the types of information that were involved in the security event, as it says here, or will other things need to be included in that notification? I should say, just to describe the types of information that have been spilled is a tall order in and of itself. And it certainly would be helpful to have this type of system inventory, this type of data map, if you are going to suffer one of these breaches and need to respond under this notification requirement. But this is what's sort of thrown in there on the side as an, oh, by the way, there's going to be a new notification requirement. Laura, anything scintillating about this notification requirement that I may have missed?
I'd say that there's quite a bit. I mean, as you said, this would be a new significant requirement that's federal. The FTC reasoned that the proposed requirement would impose, quote, little additional burden while facilitating the agency's enforcement of the underlying rule. Importantly, it anticipated making the reported information public through a database that it would update periodically. It proposed that the notification requirement would not allow for any delay of the 30-day notification obligation. And for those folks that are on the webinar who deal with breach notification, I'm sorry, that delay, there would be no delay for companies cooperating with law enforcement. And that is an outlier in terms of the alignment with state law. And that raises concerns for a number of firms because That cooperation is important, that delay is important in order to assist with law enforcement and line things up. And so it'll be interesting to see what the comments are on the rule, on the SNPRM. The deadline for comments is February 7th. So that's coming up. And yeah, if there's interest in that, I'm happy to take any questions.
You're on mute, Robert.
I was just going to say, Laura, when does the Safeguards Rule, this amended Safeguards Rule, so everyone knows, when does it take effect?
December 2022, December 9th.
Excellent. Excellent.
So we do have a couple additional questions in the chat.
Yeah, Laura, if we're not ready to answer these now, we can always get back to these folks later. But there was a couple of questions on are these changes expected to impact single audits?
Right. So so single audits. I'm not sure exactly what to infer from that, but the rule doesn't necessarily prescribe how you test your program, whether you do periodic audits or constant scans. So that is, again, there's still some flexibility in the rule, but if the question is instead, will this get added to the 2700 ISO series or otherwise, that's an interesting question. The standards are largely mapped to existing, the new requirements of the Safeguards Rule are largely mapped to existing standards.
Gotcha. Thanks, Laura. And then around the question, if we have time for one more, around the service provider discussion, there was a question from somebody that provides marketing services to automotive dealerships. Would that extension in the definition of financial institutions and within the context of dealer built, would a company that provides marketing services to automotive dealerships fall under the purview of safeguards?
Well, so there, I think that the person asking the question wants to take a look at the information that company is dealing with on behalf of the automobile dealership and evaluate whether their facts are analogous to the dealer built case and do an assessment on that basis.
Awesome. Thank you, Laura. Well, Robert, Laura, thank you for this. We appreciate it. You know, one of the reasons why we wanted to do this webinar is, you know, we're starting to see regulators kind of step in a little more. GLBA and the Safeguards Rule was an excellent example of them trying to clarify and kind of modernize, I guess you could say, some of these sectoral laws. And we thought it would have broad application, given that it would add to sorry, I was getting distracted by that. It would add to the zeitgeist, if you will, of regulations out there as more sectoral laws get up to date, including impacts on state privacy laws. But thank you. I think we had a final slide, Robert. Or off to Jordan, yeah.
Not muted. Thank you so much to Jonathan, Laura, and Robert. It was an awesome program. Thank you to the audience for all of your participation in the polls and the Q&A. That was great. I did drop our survey link in the chat. If you can go ahead and just give us your feedback on this specific program, and then there's a field at the end where you can give us some, open field for any commentary on programs you'd like to see in the future. Of course, I want to thank Ketch for their sponsorship of this program, so it's free to everyone. And that is about it. It wraps up our program. I hope to see you all on an IAPP web conference after the holidays. Thank you all so much.